Welcome to Newsroom, Teresa Lusk. I am here with attorney Byron Henry, and we are here to discuss the case that went before the Supreme Court. Byron, welcome to the show.
Great to be here, Teresa.
We're going to talk about the Mahmoud versus Taylor, and the Supreme Court heard this case out. It has varying details that I think are extremely important right now for America. And this case is based in Montgomery County, Maryland. And what I think is interesting about this is that Muslim, Catholic, and Orthodox Christians joined together to file this suit against Montgomery County Public Schools because they removed them the ability for parents to opt out of their elementary, take their children out of listening to any type of LGBTQ themed books, as they were doing this, from what I understand, every single day that the students were in class for June, which is Pride Month. The students had to hear something about Pride Month, and it was part of their curriculum. Is that correct?
That's right. That basically there was a focus on that specific issue, and that was kind of made part of the curriculum for that month.
Okay. So this went through other courts, and it finally made it to the Supreme Court. I actually listened to the entire hearing, if that's the correct term for it here.
The oral argument.
The oral argument. And I thought it was very interesting to hear the different justices and their approach, the way that they would question the counsel back about all these details. So give us a rundown a little bit about, you understand this, you've been speaking on constitutional law. This is very important right now in our nation. Tell us a little bit about the case so that our viewers can understand this, and then we'll break it down some more.
So this case kind of has like a combination of a couple factors. One, it has the factors of the whole books in schools and books in school library issue that's been percolating, where Texas has had a number of bills passed, other states have had bills passed, where you basically have either parents the ability to keep their kids from reading certain books, or you basically have a review committee which basically takes books out of libraries that are inappropriate content. Most of them, when we're talking about inappropriate, we're talking about inappropriate sexual content, whether it's gender issues or LGBTQ type of issues. So there's that issue combined with the whole what's going on in the classroom, not just the books itself, and just a continual belief in some school districts that the classroom is being used for much more than reading, writing, and arithmetic, but basically kind of an indoctrination, whether it's gender issues or other issues, lifestyle issues. And this kind of culminated with a school district that has opt-outs for a number of things for parents.
Correct.
And had an opt-out for things like this, and then decided to discontinue the opt-out, thus the lawsuit and the issue that came to a head that you listened to an oral argument with the Supreme Court.
Well, they did change their mind. Here's the thing, though. One of the greatest focuses based on this case is religious freedom, religious liberty. Are they not infringing on that, the school board? From what I understand, there were even some comments that the school board made that were anti-faith. And what I think is very strong in this case is that you've got not just Christians, which they're always at the forefront of so many of these religious liberty cases, but now you have Muslim, Catholics, and Orthodox Christians. So where does the faith part come in as far as constitutional rights, et cetera?
So this is probably kind of a hybrid case of parental rights. You could probably have a case like this that had nothing to do with religion. In this case, it just has to do with another provision of the Constitution, the First Amendment, dealing with free exercise. And basically, when you combine that free exercise with the parent's right, the constitutional right to control the upbringing of your child, and the fact that the Supreme Court has ruled that although public schools have a good bit of authority with respect to what goes on in the walls, it's not plenary, meaning the parents still retain rights with respect to certain issues. So in this case, you basically have those two things combining, and other members of other faith. It's just like, we're the parents. If you're going to do what they would consider ancillary things, not curriculum, but ancillary issues like Pride Month, we should have the ability to opt our child out of something like Pride Month reading, or they might consider it Pride Month indoctrination, however you want to characterize it. And the Supreme Court tended to lean in favor in the oral argument. Well, I'm sure we'll get to that, but certainly there's a strong argument for the parents retaining the right to opt out of things that are ancillary. So if there was a field trip to some place that was possibly inappropriate for a certain school age child, most schools have the ability for parents just not to approve the field trip. And that's pretty standard. So now we're getting into actually stuff in the classroom where students would actually have to leave the classroom, which gets a little bit more technical than just a student not going on certain field trips. But that's kind of what we've waded into now, where the parents pushing that. And in this case, as you noted, a number of faiths are opposed to this kind of ancillary teaching or instruction on these issues, especially these sensitive issues for younger children too. This is not like juniors in high school. These are younger children that there's an argument of whether or not any sexual type of issues are appropriate for that age.
Well, you brought up the age thing because I was listening to the oral argument. I actually listened to it twice and I found it fascinating, of course, but that's why we're doing this segment right here, because this was such an important part. I heard some tones of almost questioning if any of this was dependent on the age of the child. And as a, as one who understands your constitutional right, I think it doesn't matter. It doesn't matter if the child is 16, 12, 5. If the parent does not want their child exposed to that because it goes against their moral upbringing, their convictions, etc., shouldn't they retain the right to hold to those convictions and enforce that in a public setting, such as a public school?
So if you're dealing strictly with the free exercise and parental rights, the answer would be yes. I mean, it wouldn't matter if they were 17 or if they were 5. If it's the parents' rights to upbringing and also the free exercise issue, then you would say yes. But the Supreme Court has also talked about older children being exposed to different things and viewpoints generically, like objectively, not like indoctrination, like this is good or bad, but just being exposed to things at the older ages, just in generic curriculum and generic history and science that should be acceptable because of the age of the child. So I agree with you, except that the Supreme Court does have some, and other courts have some cases out there that talk about, when they're older, they can be exposed to things without being taught that these are right or wrong. Or this is, so I think that's really the main difference. And most of the time you're going to get way more objections from parents for faith reasons or just non-faith reasons. Just this is my child. I'm going to determine what they're exposed to for the younger age kids. And so that's really the forefront right now, though, of course, under what we're discussing, First Amendment principles, it would apply all the way up to any age in school.
But there is a difference between exposure and just being taught in it, being instructed in it, being taught that this is what we do. This is for the sake of inclusivity. And I thought, even as I was listening to the case, I thought, well, inclusivity to some degree can be objective. It can be objective to some degree, because if we're talking about a parent who has strong religious rights, they may not see that as inclusivity. They may just see it as an infringement upon their religious convictions once again. So I go back to that, Byron, because I think that's really one of the things that came out, even as I listened to the justices. There was a couple of them that as they were questioning, they were seemingly hostile to the way that they were questioning regarding the parents' desires to keep their children from being taught this, et cetera. What are your thoughts on that part of it?
Well, there is, especially from some of the left-leaning justices, what you're going to get is kind of a slippery slope / are you allowed to opt your child out of every single part of the curriculum that you disagree with? So whether it's a science-based curriculum, whether it's a health-based curriculum, whether it's, I don't know what could possibly be objectionable in math, but let's go to literature, not just sexually explicit books, or basically kind of not taking an objective view, but kind of indoctrinating that certain lifestyles are acceptable or maybe even morally correct, all the way to just generally acknowledging that these things exist in the world. And so I think the left-leaning justices playing kind of a slippery slope argument that the Supreme Court has always said that's not where we are. That is not a situation where parents can just object to every single study or lesson that they disagree with, or they don't want their child exposed to. That's not where we are. So they're using that as kind of a pushback against the whole, well, this is just this, or this is just that. I think the response to that is that there's a pretty settled body of law that there are certain areas that the state should just stay away from, and the core educational function, that whatever that is, this wasn't that.
Well,
This isn't it.
Well, didn't they prove that this was very much about imposing a lesson on inclusivity if you're going to take a book every single day of the week and teach on it for the entire month of June? I mean, does that not prove the point of the parent?
Well, yeah, the difference would be whether or not there's a lesson about these things exist and you should be aware of them at the appropriate age versus celebrating it. And so anytime you celebrate something, you are, whether you say it outright or not, you are objectively instructing the students that this is not only acceptable, but if you're celebrating it, it is desired. So anything you celebrate, whether it's winning a state championship or getting a gold medal or getting straight A's, is you are celebrating something. You are telling the students this is not just exists, it's acceptable, but it is desired. And so that is way beyond simply objectively teaching children that things exist in the world they need to be exposed to.
Well, that's a great way to put it. Here's some of the books that were incorporated into the curriculum. Pride Puppy, Uncle Bobby's Wedding, Prince and Knight, Love, Violet, Born Ready, the true story of a boy named Penelope, Intersection Allies, We Make Room for All, and My Rainbow. So those are definitely books that are focused on pushing an agenda that now parents have to sit back and, if the Supreme Court was to rule unfavorably, I mean, this kind of sets a precedent for everybody who has a religious conviction. I thought it was very interesting. One of the things I understand as a faith person is that the Supreme Court justices, a lot of times, they don't really have an understanding of how or why a parent of faith makes these decisions. It is not based on discrimination. It is based on a conviction to a book, which is the Bible, or for the Muslims, the Quran, etc. What do you have to say about some of these books? And because you were talking about that in the beginning, like this is going to set precedents really for the books that are in the library, et cetera. How far will this portion reach, even looking at the books that were mentioned?
So the difference between instruction on some of these issues, first of all, you have to determine whether anything with respect to what they call gender dysphoria or trans individuals or that whole process or your sexual orientation with respect to who you want to marry or have relations with is appropriate for elementary school students, especially, grades 2 to 4 or kindergarten to 4th grade, 8, 9 years old. So that's the first question. Is it even appropriate also? A lot of parents who have no problem with some of these issues from a political standpoint would be like, that's just too young for my young one to be learning about anything sexual.
Right.
So there's that issue. But then the way the books present them is, as we discussed, this is not a dry instructional criteria to let the kids know that there is an entire community out there that are allowed to marry under the Supreme Court precedent, and according to the Supreme Court, the Constitution protects that, that are same sex, that are same gender. So that is different than teaching that. This is basically celebrating and trying to normalize. And to normalize and to desire it is to tell kids, if their parents believe it's wrong, or if they go to church on Sunday and they learn that this is a sin and that we love people, all sinners, wherever they are, right, but that this is sinful conduct, you're basically contradicting during school what your parents at home or your faith leaders are teaching you outside. And what parents are saying is, just because we send our kids to public schools, which is required, by the way, by law, most of it's compulsory, does not mean that we have to allow our children to be taught the antithesis of some of our core religious beliefs. And that is a very strong argument. And the Supreme Court has been very receptive to that argument in recent years.
Well, Justice Jackson said that basically they don't have to have their children. They could find other options. And I thought that was quite shocking, actually, being that we're all taxpayers. And we're all really required to send our kids to public school for the most part. Most parents cannot afford it. And then, of course, she commented on that as well. The truth is that we're all taxpayers. So where is the division between, your constitutional right to have the freedom of religious expression and then freedom from religion? If a Supreme Court justice herself is saying, if you don't like that, then take your child somewhere else. How does an American who is being protected by the Constitution, and she is supposed to uphold that, how do we navigate that?
So there's two answers to that question. One is in broad strokes. You've basically touched on the what seems to be eternal fight and conflict in the First Amendment, as well as in society between the left and the right. The left is basically religion does not belong in public universities, public schools,
Right.
the public square. It does not belong there. It belongs in churches and in homes, or maybe private schools to the extent they allow them to exist and function in those states. That's where it belongs. So it doesn't belong out there. So that Justice Sotomayor is being honest, I think, and betraying the argument on the left is that you shouldn't, if you want religion, if you want morally aligned teaching, if you don't want to be offended by something or whatnot, or you believe your religion, then just take them out of public schools. Mm-hmm. You can't be in public schools. Right. So that's a big fight. And it's just basically, in a nutshell, that's what's happening here in this one situation is the fight between the Justices Sotomayors of the world. And that viewpoint is you just don't believe, or Justice mm-hmm. Jackson, you don't believe that you can be in the public schools. So, right. So if you're religious, if you're a Christian and a principled Christian that practices your faith and actually believes what Scripture says about salvation and sin and whatnot, mm-hmm. you basically, your option in some states is not to send your kid to public school. And since it's compulsory, it's to send them to private school. And some states don't even allow homeschooling. So I'm not sure that they're fully aware of the options that their states have for kids that are parents that want to take their kids out of public school.
Well, as I was listening to the case, they were talking about one of the students, I guess, ended up going to public school, and it became such a financial burden to them. Some others, who maybe say, well, we don't need to have any kind of religion in schools, etc. Go ahead, go somewhere else. Again, these are taxpayers who also pay into the school system. So anybody who has a religious conviction should be able to opt out of that. Is that correct? And why does the school board have so much power in this choice? It's a school board. How do they get to make such a decision for parents and override constitutional rights?
So first of all, the school districts are the government. So it's basically They have power because they're governmental institutions. You can boil it down to the school board, but the school board represents the school district, which is basically a governmental entity. So the schools the public schools are government branches, if nothing else. They're not the government, but they're a branch of the government. They have governmental powers, governmental immunity. So that's why they're so powerful. And they have a lot of money. They can tax you. They have billions of dollars at their disposal for lawyers and for lobbying. So they're very powerful. But the real test is the Supreme Court does not like to micromanage schools. Let's be honest. You don't want a system where there are 5,000 check boxes on an opt-out form so that it costs more money to manage kids that are opting out of things. So from a practical standpoint, the Supreme Court is careful not to, quote, micromanage the schools. So these cases you find going up to the Supreme Court, and these are usually the most onerous or extreme versions of school boards or school districts taking an outlier position, meaning they have stepped out of the generally accepted management that the courts allow them to manage things so far outside the lines that they need to be pulled back. Mm-hmm. So this would be one of them, especially the age of the kids. So you're looking at young children, interfaith alliance, two provisions of the Constitution, both the free exercise clause and the provision about parental upbringing. The fact that a lot of states don't allow options for taking kids out of public school or homeschooling, or they can't afford, there's no scholarship or voucher for private schools. So you combine all those things and it makes the case the Supreme Court basically said, I think it might've been Justice Gorsuch or Kavanaugh that basically said, wait a minute, you have opt-outs for tons of stuff at this school.
Right.
So what is the big deal about opting out these young kids? And they actually questioned, I think, in their questioning, signaled that they weren't even sure that this was appropriate material at all for this age.
Yes.
But in any event, assuming it was, the parents wanted opt-out. So that's kind of the dynamics you have going in this case. And I think it's probably a win for the parents. And that's generally the trend, but it will not be a small victory. It would be a big victory for parents because it would be a legitimate victory where a school district has said, we really just can't have kids opting out and going out of class that much. We can't manage it as a school. And the Supreme Court is basically saying, sorry, just deal with it. Right. The Constitution requires you to deal with it.
Absolutely. And I think that would be, I think that's very important for everybody, even people that aren't faith-based people. being forced to have to listen to something that they just feel completely that they disagree with, regardless if I'm a faith person and you're a faith person. That's what the Constitution protects, their right to say, no, thank you. This defiles my conscience, whatever you have with it. Here's some quotes from the Supreme Court hearing. Justice Samuel Alito, Chloe, this based on the book, has reservations about in the marriage, and she's told she shouldn't have any reservations about it from the mom. And it says, he says, that's a clear moral message that a lot of religious people would disagree with. Absolutely. If your child is being exposed to a book where it's contrary, again, like you mentioned earlier, to what is it that you're being taught at home. Of course, in this case, it's the mom telling her, hey, this is okay. You shouldn't be worried about it. You shouldn't be worried about it. So I was glad that he acknowledged that. Any thoughts on that?
Yes, the state co-opting the voice of a parent to basically combine to say the mom's okay with it, your school and school teacher's okay with it, so you should be okay with it.
That's
and once
right.
again, we're not even getting to the issue of whether or not the subject matter is taught. These are clear moral judgments of celebrating or basically rebuking those that would have a different view.
Right.
So it's almost as if they're not just saying, hey, this exists and you need to be respectful that this exists. This is, you need to celebrate it. And if you don't, you have a problem. Like you have, there's something wrong with you or your family or your faith or your pastor or whoever it is, or your friend group or whatever. There's something wrong with that if you take a different view of any of these communities or any of these behaviors than what our books tell you or what you learn in schools. And that is a major step at coloring outside the lines for a school district to take, and the Supreme Court took note of it.
Right. And of course, the psychological issues that it could cause a child anyway of that age who's got these two differing opinions and views, and they really respect, because at that age, children really do care about what the teachers are saying. I remember my daughter, when she was in elementary, her teacher was teaching on evolution, and I just couldn't get my child out of that because she was determined that her teacher, Mrs. So-and-so, was absolutely correct. And it was a little bit of a battle. Justice Neil Gorsuch said he highlighted a school board member's remarks calling objecting parents white supremacists and xenophobes, suggesting that this shows unconstitutional hostility toward religion. What do you say to that?
It is. There's subtle hostility, meaning like there's no problem with this, and anyone that has a problem with it, they have a problem. That's subtle. Or just coming right out and naming groups or individuals or viewpoints that are incorrect or discriminatory is basically the way they're taught, is that any negative thoughts you have about this whatsoever are discriminatory and hate. And actually they use terms that are much stronger, and because kids are always taught not to hate in most faiths and most homes, even secular homes. You shouldn't hate people. You shouldn't hate your neighbor. You should love your neighbor. You should be kind. But to say that, it's hateful to say that, it's hateful to have an issue with or to question whether or not it's proper or right or morally right or wrong for same-sex partners to get married, or with respect to transition or gender transitions, and be confused about whether you're a boy or girl, that those are morally closed arguments in school, and that everyone outside the state's viewpoint is on the outside. The First Amendment was designed to make sure, number one, that the state didn't take a viewpoint. But more importantly, that they didn't impose their viewpoint or create outsiders on the non-state sanctioned viewpoint. So the freedom of speech is important. People think, well, it just means I can say what I want. Well, it actually means a lot more than that. It means the government can't use the force of government to make you feel like you're saying the wrong thing.
That's right. That's right. That's very important. I think those are great points. And then I'm going to give Kavanaugh's, and he questioned the necessity of exposing children to content that may conflict with family religious beliefs, implying that a lack of opt-outs could infringe on religious liberty. And that is absolutely true to the core. I would be so concerned if I couldn't opt my child out of certain curriculums, not just this, other things. They can decide to start teaching some other stuff that we may not be in agreement with, and what's important for parents to know, even as we're looking at this case, I think that this is absolutely important. I think parents and America should be listening to this case. It is so important for our future.
It is, and it is just the Bill of Rights, the First Amendment, was designed for this very situation where the government has overstepped its bounds. And I would simply counsel parents to, I don't believe that the case law exists out there, the precedent exists out there for you to complain about every single thing that your child sees, reads, or hears at school. That being said, if you don't contact a constitutional lawyer or someone who understands what the law is in that area, you won't know.
That's right.
So, but certainly with young children and sexual related issues that are obviously moral issues that a lot of religions, including Christianity, take positions on, and the Muslim faith and lots of faiths,
right,
Jewish faith. Those issues are certainly things that are going to be the ones that are the most covered in case law, probably the ones where school districts have the most opt-outs. And a lot of times there are opt-outs available parents don't know about because school districts don't publicize them. Because if they publicize them, people take advantage of them, and it can be an administrative nightmare for a school. So a lot of times parents need to educate themselves is just what does my school allow an opt-out for. I was surprised, by the way, by the number of other opt-outs that this Maryland school district had when they shut this one down.
So do they just contact the school district to get those? I mean,
yes, absolutely.
So just email them and say, I would like a list of your opt-outs.
And just a reminder that while it is the government, like the government of, the legislative branch or the president that we elect, most school boards in Texas, all of them are elected.
Right.
Meaning that election comes up every 2 to 3 years, and it's a local election. Most of them around here are purportedly nonpartisan, but it's very important, regardless of what the party label is, that you ask questions of those candidates specifically about parental rights, and what about opt-outs, and what about inappropriate curriculum at young ages, and do you allow an opt-out? If you're going to, do you teach it at all, and if so, will you allow an opt-out? That kind of thing.
Well, that's great, because we're in, if you're in a conservative state such as Texas, that's great, but not everybody gets those privileges, unfortunately, right? I mean, not everybody. Some of them have a lot more strict rules, and I mean, they basically the government tells you what you're going to do. In this case.
Generally, the government will tell everybody what to do in every state if you allow them to. So it's usually up to the people, and Texas generally has a little bit more of an independent streak running Texans in general. And we've kind of been more disruptors in the past and currently. And so that kind of lends itself to the conservative side. And so we do have a little bit more accountability on school boards, but you read stories every day about, even in conservative areas, school boards making decisions, or things are happening in schools that you're like, really, in that town or in that city? That really surprises me. So it's just up to parents to be vocal with their school boards, and also vocal with teachers and whatnot, because they have that right. The Supreme Court has ruled that they have that right.
Absolutely. Well, and we're talking to all of America, because while we are in the wonderful state of Texas, we just have so many people all over America that are they're running into this intersection of, are the school boards that important? And the answer is absolutely, as you just mentioned, that we just had our elections. And even, as I was moderating one of the events, you start learning just how much these people who are running really line up with your values or not. And unfortunately, obviously the municipal elections have lower numbers, I think, as far as
way lower
turnout. Yes.
Way lower.
So that really does mark our area, and so what else would you like to tell us about this case as we wrap up?
Well, I would just say that this is an important case. It's not the end all be all for religious freedom in schools. There's a lot of other issues, but this is a big one, just to remind school districts that if they're going to include, remember, this isn't about whether or not you can include this curriculum for an entire month for young school age kids. That's a different case. You heard a few of the conservative justices kind of express skepticism indirectly through their questions, that they weren't sure that this should be being taught at all at this age. But that's not the case. The case is not about whether they can teach it. That's probably up to parents and the school district and the voters, whether or not they should include this. It's about whether or not, if they're going to choose this kind of ancillary, we keep calling it curriculum. That's very generous to the school district. This is basically a celebration of a lifestyle for a month during a school year, as if the kids have enough time for that when they need to learn all 100%.
And what else do we celebrate? What else do our students celebrate for an entire month?
Celebrating
entire
you know,
month.
the
Yes.
revolution or
Yeah.
victory in World War II. Who knows? The answer is I bet they don't.
Yeah.
But I don't want to paint with a broad brush.
Well,
The
I
school
taught for
district
a
may
little
be
bit. They don't. Not for an entire
this school
month.
district may be very patriotic, but I
Yeah.
can't imagine spending a month on books about a cultural sexual issue, which is, there's no other way to put it. I mean, these
Right.
are sexual issues, no matter how you dress them up as a puppy or a wedding or whatnot. These are moral issues that are of high import to a lot of families and a lot of people of religious faith. And those things, parents need the right to make sure their young children are not exposed to. In this case, will be national.
That's right.
It will basically, and this was a provision of the Oklahoma Constitution,
Mm-hmm.
which is basically the Supreme Court would be saying that if that's what the Oklahoma Constitution allows, that is unconstitutional. So you can't, because remember, the Supreme Court of Oklahoma ruled under its constitution.
Yeah.
So my view, or excuse me, this was a Maryland case. So this was a Maryland case. So in the Maryland case, what you're looking at is a nationwide mandate that if you're going to do this, and a lot of schools just won't do it because administratively it will be a nightmare for them to manage opt-outs in their district. So this decision could not just allow parents to have more rights. It could get rid of a lot of this controversial curriculum, as we're calling it, from the schools altogether.
Well, I think that would be wonderful, just so that we can get back to focusing on things that matter, things, education that matters, get the students to higher standards, et cetera. And I think, you've got a very short amount of time in each class period. So it would make such a difference if we could focus on things like that. Byron, you are with, the name of your practice is
Henry Hill.
Okay. And that's, where can people find you if they've got questions about?
So locally, our offices are in Frisco, Texas at Hall Office Park, and you can reach me at bhenry@henryhilltx.com. And our website is henryhilltx.com.
All right. Well, thank you so much for coming on today and talking about this wonderful case. We look forward to seeing what all is going to happen, how the Supreme Court will rule. And let's just hope that they're going to rule constitutionally. That's all I care about.
Agree. It should be end of June. These controversial decisions seem to come out in the last week. So you should see a decision sometime in the end of June.
There you go. Well, thank you so much. And you have been tuned in with Newsroom, Teresa Lusk, and we'll see you again soon.